the serious or heinous offense, your lordship, which cannot be quashed, your lordship.
It will be difficult.
Yes, your lordship.
My lord, I have a license holder, guns license.
But then you have used.
But my lord, Section 30 of the Arms Act, it is a well-established procedural law. The principle of law does not constitute Arms Act, my lord. My lord, it is a well-established procedural law. The principle of law does not constitute Arms Act, my lord.
30 is
30.
what is the punishment?
Your lordship, punishment.
6 months.
6 months.
Yes.
Arms Act.
Six months with
6 months, your lordship.
with fine.
Contravention of the condition of the license, your lordship. And here, your lordship, in fact, in my humble understanding, your sanction is also not required, your lordship, under Section 39 of the Arms Act, because it's a violation of, not violation of Section 3.
And it may result into cancellation of the.
Yes, your lordship.
Your lordship, with the petitioner number 1 and 2 have decided to leave peacefully.
Maybe. What the Rana PP is submitting that since it involves with the Arms Act under Section 13, it is a case of the state. Now, probably you may have to undergo the trial.
Yes, your lordship.
So none of the witnesses has been examined. Whether the arms were seized? No, could not be.
Your lordship, nothing is with us, your
Given
lordship.
opportunity, whether the arms were seized, what are the findings? Can record can be called for?
Yes, record can be, scan copy, your lordship.
Can copy?
Yes, your lordship. However, your lordship, the proceeding may not be stayed, in light of the Lakshmi Narayan case.
Yes.
Yes.
There is a charge also framed proceeding. Trial already begun. Yes, Mr. You are Mr.
Tato mine.
Tato?
Mine.
Could you write?
Your lordship, the arms were recovered, your lordship. It's clearly there in the charge sheet, page number 29.
seized.
Yes. During apprehension, the following recoveries has been made. Revolver, 32 MK and 3 SAF Kanpur made Indian 2018 U293 bullet 21 live round KF32 and WL license number so and so, which was found, your lordship.
This has to be found.
My lord, I'll carry the gun, but I'm a license holder and there is no mens rea.
But can you use?
Yes, sir. Section 30 provides for that only, the violation of the condition.
I've also heard Mr. Atel planted additional PP for the state of Arunachal Pradesh. So, this is an application under 482, under Section 482 of the Code of Criminal Procedure, 1973. Praying for quashing and setting aside of the GR case, GR number 45 of 23, arising out of pending before the court of
Chief Judicial Magistrate.
Magistrate Where, which court?
Daporizio.
Daporizio. Arising out of, no, arising out of Daporizio PS case number 29/23 under section 354,
354 IPC,
509,
509 IPC,
506 of IPC, read with section 25.
30.
What is this 25 mean?
Your Lordship, initially, the case was registered under section
25.
25(1)A of Arms Act. And the charge will frame under,
So this is arising out of, I'm saying IPC, huh? Okay, arising out of, so, okay, read with section 25 within brackets 1A of Arms Act 1959. Okay, and the charge is framed against the accused under section 354, 509, 323 IPC, read with section 30 of Arms Act. Start, huh? So, okay. The informant is also the petitioners.
Yes, my lord.
it's a joint petition.
Issued
Joint
petition, returnable by 4 weeks. For the scanned copy of the LCR. Start, huh? Since Mr. Ete, Planet Additional PP, has accepted notice on behalf of the respondent, and no formal notice need be issued to the said respondent. Start, huh? List this matter after. The Daporizio would take time 4 weeks.
Yes, Your Lordship, after
Okay.
4 weeks.
Your lordship, in that case, interim may allow. That would be grateful, my lord.
Trial has begun. No interim.
We have already, my lord, we have already settled the matter. There is settlement, my lord.
Let us see if the matter under Arms Act can be settled
Yes.
by the individual party. Okay.
Highly obliged.
I think it will. Okay,
Please, Mayor, please.
yes,
Joseph, this is also a joint criminal petition under 482 for quashing of the FIR and the
Quashing
trial
of FIR.
quashing of FIR and trial proceeding also,
Trial
on the
proceeding.
basis of settlement arrived between the parties.
Okay, what is the offense?
Offense is Lordship 394, voluntarily causing hurt in committing robbery.
for committing?
Robbery.
Okay,
This is FIR was lodged by the present petitioner number 1.
petition number
Yes, 1.
1.
Yes, he is the complainant. He is the petitioner, and now after settlement, this application has been jointly filed also.
So, there are 2 accused.
Yes, 2 accused, petitioner
Okay.
number 3 and 4, 2 and 3 also.
Okay, just let us see once the FIR, the allegation.
Yes, may I take you to the FIR, copy of FIR, Lordship, case number 20.
Okay,
Mayor, Lordship.
yes, yes.
Subject FIR. With due respect, I have the honor to inform you that today on 8/6/2022, in
Okay.
between,
So police investigated.
yes, police
Charge
investigated.
is filed.
Charge sheet was
Charge
filed.
is also under same
Same 394
offense,
laws.
39434.
Yes, 34 laws.
Okay, so what is the stage in the?
This is
before the
evidence,
trial
is this.
court? Huh?
Evidence is this.
Evidence stage.
Yeah.
Any evidence already recorded, produced? Not yet.
That I have no, charge has been framed, that is,
Charge
has
also
been
framed,
told to me.
Okay. So, yes, there are also,
Yes, Your Lordship, scan copy of the LCR may be called for Your Lordship.
Lordship, this is a covered case in the judgment passed by our Honorable High Court in Golokia versus State of AP. Here also same offense under 394. It was caused on the basis of settlement error between the parties, Lordship.
let us see if it is covered case. We have to see the statement and, just a minute, sir. They have also annexed 161 statement of the victim.
Yes,
Have you-
Lordship.
Where is the statement of the victim?
Victim, Lordship.
Only charge sheet has been annexed perhaps, your lordship.
Some.
Statement, it's in page number
Yes, it's
33.
there, it's there. 33.
Yes, your lordship.
Yes, page 33, Lordship.
Was coming back to Pasigat from Alovia in Kyong after delivering boiler at 49 Battalion ITBP Training Center. When I reached Ranegat, Tinali, two unknown youth stopped my vehicle and asked me and my driver to come out of the vehicle and demanded money. When I refused to pay them, one of the youth started physically assaulting me with fist blow and also with an iron rod. As a result, I sustained injury on my face without any fault
They are
of mine.
stranger only.
Yes, your lordship.
Okay. Mr. Lovely, huh? Came over Land Council for petitioner. I've also had Mr. Echo, Land Additional PP for the state of AP. Para. By this application under section, by filing this application under section 482 of the Code of Criminal Procedure 1973, the petitioner prays for washing and setting aside the FIR dated 8/6/2022 and charge sheet number 17 for 22 and trial proceeding affidavit, charge sheet number so and trial proceeding being GR case number 112/22 arising out of Pasigat PS case number 66/2022 under section 394/34 IPC pending before the Court of Chief Judicial Magistrate Pasigat. Issue notice returnable by 4 weeks. Call for the scanned copy of the LCR. Since Mr. Epe, Learned Additional PP has accepted notice on behalf of the state respondent, no formal notice need be issued to the said respondent. List this matter after 4 weeks. Okay.
Lordship, I have interim prayer, Lordship, since Lordship, the matter has been settled. And if the proceedings not stayed, then the purpose of settlement it arrive between the parties that may be frustrated. Lordship, till the receipt of the LCR.
I will,
What is your submission? Huh?
I would like to leave it to your lordship discretion, your lordship.
Where is the covered case?
Lordship, here, Lordship, this is Sri Golo Khaya, criminal petition number 46 of 2019 and judgment decided on 13/9/2021. May I read FERA 15, 16 and 17, last page, Lordship. 15, 16,
Yes.
15. Further, it appears that even if trial is allowed to complete, then also there will hardly be any sense of conviction as it cannot be expected that the petitioner number 3, who is the informant, of this
in
case,
the heart, whether medical documents are also there.
yes,
Annexed.
yes, medical.
Where?
But not frame under your lordship section 323.
Hmm?
Charge is not frame under section 323.
Yes.
Only
Yeah,
under, and even not under 34, your lordship. Only 394, your lordship. This is the issue here. Only under 394, Your Lordship, not
Only
even
394.
34.
But the impleadment lordship also, even in the FIR, they only demand for money, but it was not paid.
So not committed.
Not committed, attempted lordship at the best lordship,
Attempted, not succeed.
not succeeded.
No, but then probably next date has already been fixed for the evidence of the informant, probably.
PW.
Yes.
And in that case,
PPW.
since you have entered into an agreement, probably she will not give any,
Yes, Your Lordship, that we can,
adverse,
at this stage, we can say that there is a remote and bleak chance of conviction. That is one of the aspects which has to be taken into consideration while considering the joint petition, Your Lordship. The offences which doesn't fall under the restricted part, just like Your Lordship, I earlier mentioned that Arms Act and POCSO Act, these are serious offences, no doubt. That has to be considered on the basis of the material on record. But so far as these provision sections are concerned, these are the general sections. And as per my understanding, Your Lordship, this section doesn't fall under the heinous offense, but fall under, no doubt, serious offense, but not an heinous offense. So if they have settled the matter, so in that case, Your Lordship, it can be presumed at this stage,
automatically they have done.
they're hostile, Your Lordship, and a remote and bleak chance of conviction, and it will amounting to abuse of process, Your Lordship. That is my conclusion.
That has been.
Where is the medical?
Medical report is in page number 42, Your Lordship. 42 type copy, Your Lordship.
42 laws.
So that's just.
Yes, simple injury, Your Lordship.
Okay.
But the say under with the same has not been charged, Your Lordship.
It was a simple injury, but
Mm. In the meantime. Till returnable date. The proceeding of the GR case number 112/22 before the Court of Chief Judicial Magistrate Pasigad
possible.
shall remain stayed. Okay.
Obliged, Your Lordship.
Deeply obliged.
Your Lordship, this case may not be taken up by Your Lordship. Your Lordship. Last date, as on the last date, the accused was not cooperating, but as per the updated case diary, Your Lordship, the accused has appeared and cooperated with the investigation.
Oh. Has been arrested by the police also?
Yes, Your Lordship. Shown arrested and the amount has been deposited before the CGM and it has been executed properly.
No one appears for a petitioner on court. Mr. G and Mr. Sir, okay, managed ADPP, additional public prosecutor for the state is present staff. In absence of the petitioner, non-counsel for the petitioner, the matter stand adjourned. Release this matter after 2 weeks.
2 weeks. Yes. Obliged, Your Lordship.
Remove some of these papers. Yeah, I got it. I can read. Yes. No one appeared. Okay.
We are appearing, Your Lordship.
I am item number, my lord, supplementary 22, my lord.
This is not your matter, my learned
My
brother.
lord.
Please wait for your turn.
Your Lordship, on 6/5/24, this honorable court was pleased to direct for implead the victim.
Victim has been impleaded.
Seems
Any
to-
order passed?
Your Lordship, this was passed on 6/5/24. After this is the last order, Your Lordship.
6-4
6/5/24.
in the
Criminal.
filing IA or in the main application?
Your Lordship, it's a jail appeal, Your Lordship.
Jail
So-
appeal?
Yes, Your Lordship.
Okay. So there was a
Registry was directed to implead the victim.
whether impleaded?
Not perhaps, your lordship, the same will be reflected in the office note, your lordship.
Yes, probably name inserted.
Yes, now notice has to go, your lordship.
No. Okay,
The appellant side is also present, your lordship.
Yes, Your Honor, I have not received the paper book, Your Honor. Paper book I have not received. Paper book.
Not prepared yet.
the conviction is under, for what offense? POCSO?
POCSO, your lordship.
Okay. Hmm.
Section 4.
Hmm.
Okay.
Registry may be, your lordship, further direct to prepare the paper book because LCR has been received.
LCR already received. Okay.
Yes.
Miss O. Bingat. Learned
Amicus.
legal aid counsel.
Amicus.
Amicus. Beautiful. Amicus Curie. Also have Mr. Ete, Learned additional PP, public prosecutor for the state staff. In compliance of the order dated 6/5/2024, the victim has been impleaded as respondent number 2 in the instant case. Then she is the markers who will take steps.
Your lordship, registry may be direct.
Okay, the registry is directed to issue notice upon the respondent. Number two, newly impleaded respondent number 2 by a registered post with AD within a week from today. Please this matter after 4 weeks.
Yes, sir. Deeply obliged, your lordship.
Okay, just a minute. The LCR as called for has been received. The registry shall also prepare paper book answer and this the matter. No. Let
Yes,
it
yes,
come.
yes, after returnable data, your lordship. Okay, obliged, your lordship.
Paper book and have furnished a copy to the parties. Okay.
Again, your lordship, this matter may not be taken up by your lordship. Your lordship was,
Oh, is it?
yes, your lordship.
I know, so.
Yes, page number 7, your lordship will find, your lordship, on the paper book.
Okay. This
Page number 7, your lordship, of the paper book.
page 7 of the judgment.
Paper book, your lordship,
Oh,
paper
paper
book.
book.
Yes, your lordship.
Where the paper book? Oh, yes. Judgment. Okay. List. This is conviction under what, for what offense?
Re-
Section 5. So,
POCSO again, your lordship.
okay. Okay, list this matter before the appropriate and appropriate court without me. Saying, huh?
Obliged, your lordship.
Lordship. Here also same, Your Lordship. Charges were,
Framed by me.
Your Lordship.
Okay, by
So-
this court. Okay, similar. Order. Okay. Go.
Item number 11.
No one appears on behalf, no one appears. for the petition in court. Mr. Ete, Lana additional PP is present, stop. The notice upon the respondent number 2 is still is awaited. In view of the above, list this matter after 2 weeks.
2 weeks, Your Lordship.
Okay.
Deeply obliged.
Yes.
My lord, I have taken step upon the respondent.
Steps.
Yes, complainant, but AD is still yet to be received.
Okay. Line counsel for the petition. Mr.
Odugong.
Dugong. Okay, Dugong. Is present. Notice upon the respondent number 2. Only 2.
Yes, it's
Still
complainant.
awaited. Please, great. Come on, list this matter after 2 weeks.
Actually, it is a sole respondent. Actually, it's reflected as two, but it's sole respondent.
Respondent number 2.
Yes,
How he is sole respondent? He's
Since-
2. Well, who is 1?
in our petition, there is only sole one respondent. my lord.
Office note. In respect of respondent number 2, that means sole respondent, it appears. Okay. The notice upon the respondent is still awaited. Huh? Okay. In view of the above, list this matter. You want to take fresh step or just wait?
We'll wait for some time.
Wait, okay.
Yes.
List this matter up 2 weeks. Okay.
There is interim order that may be continued.
Interim also there.
Yes.
The interim order passed earlier shall continue till the next date. Okay.
Obliged.
Your Lordship, here is the case of the husband and wife. Sir. The husband and wife filed a joint petition.
Okay.
Your Lordship, here the parties marriage in the year 2010, Your Lordship. In begotten their wedlock 2 sons. On 28/9/2022 night, the petitioner number 1, that is husband, came home drunk and physically assault to the petitioner number 2, that is wife. Hence, on 29/9/2022, FR was lost here. That is page 8.
Page
Page 8, annexure 1. Page, come to the page 11, Your Lordship.
yes,
May read.
yes.
FR against Sri Hopata. This is the petition number 1, husband. Respected Madam, with due respect, I have to inform you that yesterday while we were about to sleep, he asked me to arrange a loan of rupees so and so from someone. I could not arrange. When I refused to arrange, started assaulting me and cut all of my hair and banged my head and on the table. Due to this, I sustained injury and was bleeding profusely. While he was assaulting his sister and so and few neighbors intervened and stopped him from further assaulting me. If I'm not for them, he would be assault me more. I ran away from my own house and informed my sister-in-law. Now I fear to return home as he will assault me anytime he see me. He has caused grievous injury by banging my head on the table, due to which I had to stay my wound in the hospital at around so and so today. We both are married since 2010 and we have two sons of our wedlock. My husband started having extramarital affair since 2018. Since then, he had affair with 3 other women. Whenever he was affair, he will
Okay,
started
so-
having.
Whether
This is
charge
the
is
case.
submitted?
Thereafter, what happened? The parties are both the sides. They have come intervene from the petitioner 1 and petitioner 2 side. Then the amicably settled. That's the annexure 2 years.
No, whether the
Page
investigation completed, charge is submitted.
The charge is submitted. Charge is submitted under section of 498A oblique 323. 323,
23, not 26.
not 26.
Okay. Then trial began,
Trial is started, someone is started.
someone started. None of the witnesses has been examined so far,
Yeah, no, not examined.
not examined. Since we have received the
Yes, can be.
LCR, we can fix it for admission here.
Yes, yes.
Yes.
Fixed for admission here.
Hmm. When? Next week,
Next week.
or Mr. You're Mr.
T.
Hmm. This is item. Okay, 13. T. Gatti, Tabo Gatti. Lani counsel for the petitioner. Staff. I've also heard Mr. Hete, Lani additional PP for the state staff. This is scanned copy or the original?
Scan copy.
Scan. Okay, the scanned copy of the LCR has been received. List this matter for admission hearing after a week.
Yes, sir.
And maybe fix at the 26.
27.
Yes, 27.
Okay. As prayed for by the Lana Council for the parties, list this matter on 27. Okay.
Obliged.
Okay.
May I, Your Lordship? Your Lordship, as per the case report, the service report upon respondent number 2226 still awaited, Your Lordship. However, Your Lordship, from the source, we have identified and confirmed that the respondent, they have already received the service copies. But despite receiving the service copy, they are not.
No, it says it's still awaited.
Yes, Your Lordship, but they have already received the copy, service copies.
Mhm.
We have identified from the source. Since there are more than.
How do we?
So,
It
Your
hasn't
Lordship,
come yet.
Yes. Let await for the service report.
Let us wait for some days.
Yes.
or else, Your Lordship, we may take any alternate method.
Alternate.
Yes,
Wait. Okay,
Will-
what is this case about?
This is a
Criminal revision, Your Lordship.
criminal
They
revision.
have challenged the discharge order of this learned trial court, where all the accused has been discharged. Actually, Your Lordship, they all were Gram Panchayat member.
Okay.
So they come under the definition of section 21 of the IPC. So whatever they have acted, it was found to be act done in discharge of official duty. So without prior prosecution sanction, they cannot be prosecuted. So basing on that, they were discharged.
Okay.
So
So
they are challenging the
let-
discharge
let-
order.
Let the report come.
Yes, Your
Okay,
Lordship.
let us ensure that they have received,
Yes,
and
Your-
then we'll proceed.
Or meantime, like we can take any alternate,
Alternate, you
Yes.
want to take fresh step now?
or we'll
By
take by
alternate mode.
newspaper publication, Your Lordship.
No, not permissible under CRPC, Your Lordship. They may be taken step through jurisdictional police station, no issue, Your Lordship, but dusty service and paper publication is not
Since-
permissible.
You know that they have already received, probably it will come,
Yes.
maybe on the way only.
Okay, Your
Let us
Lordship.
wait for some time.
Then in that case, we'll wait for some days.
Hmm. Okay, Mr.
J. Sring, Your Lordship.
Your name is there.
Your Lordship, my name is not reflected in cost list. However, it's there in the Dafalatnamas.
What series?
J. Sring.
Okay, Mr. J.
Sring.
Series. Spelling?
T-S-E-R-I-N-G.
Oh, T-S.
E-R-I-N-G.
No, J.
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 Series.
Sring.
Okay, J. Series. Because other one is also Series. That's also J. Series. Yes, that's why I confused. Okay. J. Series. Planning counsel for the petitioner. I've also heard Mr. Mete, Lanet additional PP, staff. The service report is still awaited. In view of the above, please this matter after 2 weeks.
After 3 weeks, Your Lordship.
3 weeks?
Yes, Your Lordship.
Okay. 3 weeks.
Obliged, Your Lordship.
Item number 16.
15. 15. 15. 15. This, where is 15?
Both are similar matter for 15 and 16.
Oh, 15 and 16, similar matter.
Yes, Lordship.
Okay, what is this matter?
Your
about?
Lordship, this is application for praying for immunity from prosecution of the petitioner under section 64A of NDPS Act, and quashing and setting aside of the proceeding by invoking section 482 of the CRPC.
In the NDPS case,
Yes, Lordship. And it's a small quantity, and there is a provision for immunity.
no, 21C. Small quantity means under.
Small quantity of section 20B2A.
Sorry, 20B.
Yes.
20B.
Yes,
B is not a small,
small quantity.
intermediate.
No,
20B.
yes, 20 small b.
Oh, small b.
Yes,
What is the punishment?
1 year. And
This is also quashing petition.
I'm seeking praying for immunity under section 64A of NDPS Act.
What is that?
That grants immunity. Lordship, I'll read the provision itself. 64.
NDPS Act. Just a minute. We have come under. What, 64?
A.
Yes,
Married, Lordship.
yes, please.
Immunity from prosecution to addicts volunteering for treatment. Any addict who is charged with an offense punishable under section 27 or with offense involving small quantity of narcotic drugs or psychotropic substances, who voluntarily seeks to undergo medical treatment for de-addiction from a hospital or an institution maintained or recognized by the government or a local authority and undergoes such treatment shall not be liable to prosecution under section 27 or under any other section for offense involving small quantity of narcotic drugs or psychotropic substances.
Have you made a prayer before? What? Made a prayer before the trial court?
Yes, Lordship.
Rejected?
Yes, Lordship.
Let us see what, on what ground? Which state, which district?
UP, Papumpare only.
Is there any where you have proposed to undergo treatment? or-
Lordship, I have annexed, Lordship, I will give a brief facts of the case first.
Yes, yes.
Lordship, what happened was during a investigation of a theft,
Hmm.
raid was conducted. During that raid, the petitioner along with 2 other accused were arrested consuming cannabis. Or later on, it was according to FSL, it was found it is ganja. After that, they were granted bail on the condition. They prayed that on the condition that they will undergo rehabilitation. And Lordship, the same is order has been annexed in page number 64. Lordship, if your Lordship may kindly come to page number 64 of the petition.
Yes.
This is the bail order, Lordship. Where Lordship,
Bail to the-
para
bail to
3,
the Revision petitioner.
64.
Bail to whom?
Bail to the petitioner along with other accused.
Okay.
all the three accused. Lordship, para number 3. It is to discuss the bar from Mr. So and so is suffering from multiple diseases, including so and so, has opined to the serious and unfit to kept in jail in police custody. In respect of Pemangan Pejo and Toy Karbak, being addicted, will be admitted in de-addiction center. Mr. Bam, learned counsel for appears that the wisher of the accused has already paid cost for de-addiction program at Emmanuel Rehabilitation Center in Naharlagan. Also apprised that accused from Prem Khandu will also admit in the same society. All the accusers are young and waiting for opportunity. However, as indicated in the city, they are caught carrying 355 grams, which is intermediate quantity. Lordship, here intermediate quantity because it was cannabis. First, during the investigation, it was cannabis. Later on, after the FSL report, it was determined it's ganja. That's why it's small quantity.
Okay, so at
So
the time of filing charge sheet.
Yeah, on filing charge sheet, it was in a small quantity.
Okay.
FIR was lost under intermediate quantity, but later it was on small quantity. Lordship, after that, all three of them was granted bail on the condition that they will undergo treatment, as they have voluntarily sought permission from the learned special judge to undergo treatment. So all three of them went to the treatment, or two of them has completed proper treatment. The one didn't complete it. So petitioner of item number 15 and item number 16, both of them completed their de-addiction and they have released. And I have also annexed their medical the discharge slip, page number 66, Lordship, of the petition
Discharged.
from the rehabilitation center.
Okay.
Page number 66 is the admission of a petitioner. And page number
The present petitioner.
yes, and page number 67 is the discharge. He has undergone rehabilitation for
September.
90 days.
Okay. So discharge on September.
Lordship, this is to certify, I will read, Lordship. This is to certify that Mr. Sange Dorji Thongchi, son of Dorji Thongchi, resident of village Jigaon, Rupa, West Kamen, Arunachal Pradesh, has successfully completed his treatment here at Emmanuel Rehabilitation Center. Here, he has successfully completed his rehabilitation. Then he was discharged. And the provision of 64A says the one.
Successfully completed.
Yes.
Now, the immunity on what ground?
On that he has completed his rehabilitation. As the section 64A says that when a person voluntarily goes for rehabilitation and completes his treatment, he is not liable to be prosecuted. If it's a small quantity, and this is a small quantity.
No, after granting bail only,
no, Lordship, prayer was made voluntary. We will go under rehabilitation.
On that ground, the bail was granted.
On that, bail was granted.
Now he has successfully
completed.
And thereafter also immunity is whether lines.
Yes, Lordship. I have some high court judgment also.
Okay.
I will place that.
Okay.
Lordship, this is a judgment from Karnataka High Court. Lordship, may kindly come to para 9. Page number 18.
Yes.
May I read, Lordship?
Yes, please.
As the documents indicates that the petitioner is not consuming drugs now and that he has completely de-addicted. Should he be prosecuted in the question, section 64A clearly states that an addict who has undergone treatment shall not be liable to prosecution under section 27 or any other offense involving a small quantity. The word "or" is important. It is not that only the consumer of small quantity can claim immunity. That means if the addict has undertaken treatment for de-addiction, he cannot be prosecuted at all. Any further proceeding against him in relation to offense under section 27 amounts to abuse of process of court
uh, they have also relied one more case of Madras High Court, Sanjeev Bhatnagar versus State in criminal revision case. The paragraph is given the attendant facts and circumstances, the prosecution in the instant case may at best be able to make out an offense under section 27 of NDPS. The question that arises from consideration would be whether the accused should be required to undergo trial towards his conviction for offense under section 27 of NDPS Act, and would he only thereafter be entitled to seek the benefit of section 64A of NDPS Act. Simply put, section 64A of NDPS Act is one intended to rid and user of drugs from the evil thereof and towards their rehabilitation. The end object being to facilitate a life free of drugs. This court is of a view that when the material gathered by the prosecution itself informs the petitioner to be a user of drug and not too large a quantity, the provision for rehabilitation should be given effect. Effective at the earliest. It is to be noted that in offense under section 27 of NDPS Act, no distinction is made between small and commercial quantity. The court may hasten to add that a decision in each case is to be arrived on the particular facts thereof. Here it is clear that when it is of small quantity and only the accused consumer, then section 64 should be applied, 64A. And moreover, the petitioner himself is a victim of drug menace, as he is a consumer. Drug is the evil, whereas he is a victim of drug menace. If he was a peddler, then he would have been considered as a menace.
This is of which year? 22.
2022. And
So whether LCR was called for?
no, Lordship, because the
No, then
earlier it was of the consideration.
what is the stage of?
I have also annexed that order also. I have annexed the order. Lordship, order page number 60.
The LCR is necessary?
No, LCR may not be necessary, my lord. This
Not
issue
necessary.
of law only.
Okay.
63 is the order, Lordship, where next date has been fixed. It's in for CC has just been completed.
CC under 20 C.
No, Lordship, small quantity along with for consumption only. Page number 60, Lordship. Order, CC order.
60.
Page number 63 will be the operative paragraph. 63 will, page number 63.
Yes.
Para 17. Therefore, on perusing the case records as submitted by the police under sections 173 CRPC, this court is of firm opinion that there are grounds for presuming that the accused person has committed offense. Hence, the accused persons Sangidurji Thongchi, Prem Khantu Pesurpa, and Toy Garbag are charged under section 20B2A, 27A of NDPS Act. And para 19 is someone was issued, and para 20 is for the next date for evidence. That will be the for the PW1.
$26, 27, 6. Yes, Mr. Siri.
Basically, section 64A is an reformative provision, my lord. The condition precedent for invoking a provision under 64A is that the person, the accused, must undergo a medical treatment for de-addiction. If that is being fulfilled, my lord, then obviously, my lord, immunity can always be granted from prosecution.
So this is the document annexed by the petitioner is authentic.
So I have also original is also with me. If your lordship want to peruse.
This is in order.
Yes, lordship.
So what we'll do, we'll fix it, base it on the admission hearing and try to dispose next week.
Can be done also. Before the lordship next
We'll
year,
not concern with that. That is fixed on,
on 27th, this
27th.
month.
how many accused are there in this?
Total 3 accused are there.
Three
2 have properly completed the rehabilitation,
No,
whereas
then what about these two?
Lordship,
What about these two accused persons?
2 other accused persons. Lordship, one petition,
The-
the item number 16 is the one accused.
Okay, 15 and 16.
Yes.
And what
Two.
about the third?
Other
accused?
one, he has not completed his rehabilitation as he has skipped his rehabilitation, so
Okay,
he
so
cannot
that means 15 and 16
only
are
the
similar.
similar nature.
Okay.
The proceeding against these two can be quashed, Lordship, by granting immunity.
Hmm. So the next date is fixed for evidence.
Evidence, Lordship.
Okay, evidence of
PW1 and PW2.
who is Peter? Who are
The
these?
informant and
Informant are the police or somebody?
police.
Police.
The inspector Niti Vihar.
Okay, that will not affect much. That should not affect much.
Yes.
No,
Lordship. One.
won't, because we'll consider. Let us see if you are entitled. And you say that the court is also not necessary.
Not
Low point. Okay, we'll fix on 26.
26.
Okay. Hard, Mr.
T gets
T.
so.
Gatso. Number 2. Learned counsel for the petitioner. I've also heard Mr. J. Singh, learned PP. Special PP or PP?
PP.
Hearing not?
No,
special
no.
PP. Okay. Public prosecutor, state of AP, huh? Okay. Is grateful by the Learned Counsel for the party. This is matter for admission hearing on 26. Okay. 26.
26.
26. Okay.
Obligement. 16, same order, my lord.
16.
Same.
Oh, yeah. They can have money for them.
Lordship, the council was online, Your Lordship.
May
The
I please
council was
lordship? My lord,
online.
my lord, I am for item number 22, my lord.
Okay. Yes.
May I please lordship?
Yes.
My lord, earlier occasion, your lordship asked me to show the provision from the Guwahati High Court rule that, my lord, other than the petitioners of the petition can swear the affidavit in the bail application, my lord.
Yes.
Therefore, I beg to
Yes.
refer, yes, my lord. Therefore, I beg to refer chapter 4, my lord, rule 11, my lord. 7, my lord.
Page.
Page, my lord, is this is my book, my lord. This is perhaps, my lord, my one is old
New
one, my
one.
lord. But rule number is same, my lord. Rule 7, my lord. Chapter
Okay.
4.
Chapter
4, my
4.
lord. Yes, my lord.
Chapter 4. Affidavit.
Yes, my lord. Rule 7. May I read, my lord?
Just a minute. Now. Yes, please.
Chapter 4, Rule 7, my lord. The facts stated in such application shall be verified by the solemn affirmation of the applicant or by any affidavit to be annexed to the application. Note, my lord, the affidavit may be by any person having cognizance of the facts stated. Several persons may join in the affidavit. Each deposing separately to this facts which are within his own knowledge. So, my lord,
This is correct.
when
Hmm.
yes, my lord.
Yeah, correct. But
Yes.
the learned PP raised that this is in respect of the bail application for anticipatory bail.
Anticipatory bail, my lord. This is, my lord, general, my lord.
Yes.
My lord,
In
it is
general.
it is in the practice, my lord. When this matter was reported, the registry, my lord, raised this, my lord, point, my lord. Therefore, my lord, my lord, satisfied him, my lord, and with the principal bench of the registry, my lord, consulted. Thereafter, my lord, this matter came before your lordship.
The affidavit was shown
Your,
by.
your lordship, your lordship, I would make a your lordship fair submission in this regard, your lordship.
Hmm.
No doubt, your lordship, that so far as the rule is concerned, if there is an authorization, they, on behalf of the accused, other person can swear the affidavit. No doubt, your lordship. But, your lordship, the issue here is that person must stated in the affidavit that under what circumstances the accused could not come to swear the affidavit. That has to be there. And now, your lordship may kindly see 438 of the.
Of course, it may not be applicable. Probably the law not yet enforced. But then you see the situation, it may also require that the petitioner may have to appear in person.
Yes,
at
your
the
lordship.
time of hearing.
Yes, your lordship. Your lordship may kindly see this, your lordship. This issue has been, your lordship, settled by the Delhi High Court, your lordship, which is reported in 2012 SCC online,
Okay.
Delhi 4277, your lordship. Paragraph 9 onward, your lordship. As per the rule, there is a general, your lordship, rule. It says bail. I'm not saying we are not saying, your lordship, a person cannot be authorized. It can be authorized. However, what things has to be brought into the record? Now, from 9 onward, your lordship, I will read 9, your lordship. And your lordship, I will brief of the fact is that your lordship, 4 accused is there, applicant here in this case, and 1 affidavit has been sworn. Yes, yes, your lordship. Only 1 affidavit has been sworn, and that too, that person is purportedly claiming to be the family friend, your lordship, not even a family member, and that has to be substantiated. Your lordship may kindly come to the judgment. Para 9, your lordship. The present anticipatory bail has been filed on the instruction of the Govind Kumar, who claimed himself to be the brother and Pierokar of Gopal Goyal Kanda. This is evident from the affidavit filed with this application. In the entire application, not even a word has been said as to why Gopal Goyal Kanda himself had not sworn an affidavit in support of this application. If it at all he has filed the same, even during the course of hearing, also nothing has been said in this regard by learned senior counsel appearing for him, even though the learned additional solicitor general had made a mention about the fact that the applicant had not filed his own affidavit. Considering the fact that Gopal Goyal Kanda is a free man, at least at present point of time, he alone could have moved the anticipatory bail application supported by his own affidavit. In the absence of his having done that, his application cannot be considered by this court to have actually been filed by him. A single judge bench of this court has ordered on 18/1/2007, while disposing of a bail application number so and so, Shri Vivek Pathak versus state that bail application should be supported by the affidavit of the concerned accused, and if he happened to be in custody, then only any of his close relative or authorized representative could file his affidavit along with the bail application. This is what exactly was observed in that order. In light of the peculiar fact that emerged, which could have been avoided if adequate care were taken to ensure that only those duly authorized to move bail application do so, the registry is directed to ensure that the henceforth bail application are supported by the petitioner, or if they are in custody, their close relative or authorized representative. The relationship should be disclosed clearly in the affidavit, that is such as brother, wife, son, daughter, sister, husband, uncle, etc. In case of the applicant being authorized, some supporting material should also be disclosed. These directions shall be circulated to member of the bar and separately displayed in the notice board. The direction shall be made effective from a convenient date in March 2007 to be notified in the notice board through a circular practice direction. 11. A division bench of Calcutta High Court has also held in judgment reported in so and so in the matter of Boneshwar Datta that anticipatory bail application have to be supported by the affidavit of the concerned accused himself. The relevant portion from the said judgment of Calcutta High Court are being reproduced below. Of course, while considering the application of anticipatory bail, the court does not sit in appeal over the material or the basis of which the applicant has a bona fide reason to believe, but the existence of the reason of belief is a matter which is the condition precedent for exercising jurisdiction under section 438 of the code, and that the applicant who must have reason to believe he may be arrested on the acquisition or having committed a non-bailable offense. There cannot exist any expression of the reason to believe unless there are some material in the possession of the applicant to show or suggest that he has a bona fide reason to take such view, and that judging from this angle, it is the applicant who has reason to believe may come to the court, as provided in section 438 of the code, and file an application. In such circumstances, it appears to us that whether he has reason to believe or not is a matter for him to allege, and power could not be delegated to a tabikar and who cannot file an application affirming in affidavit. Similarly, by saying that he is conversant to the fact of the case. Is considering the provision of section 438 of the Code of the Criminal Procedure, the court cannot ignore the expression he may apply to the court. Is constituting the statute, the court is bound to give effect to each and every word used in the statute. The expression he may apply could not be construed as may on application by or on behalf of a person or expression. He cannot mean that he include a stranger or a tadbikar or a thought or a middleman. Every word of the statute must be given its normal and literal meaning. The expression in our view, he by any stretch or imagination cannot be allowed to include any other person excepting as provided under the Civil Procedure Code, wherein the applicant include applicant holder of power of attorney, or where he appoint an agent as provided under the law, where he is unable to come to the court. If he have to hold the expression he include tadbikar and others, is that event we have to construe the word that he may affirm an affidavit and file an application for anticipatory bail on behalf of the person to whom he has reason to believe that he may be arrested on acquisition of non-bailable offense. In our view, the expression he could not be included and mean a stranger or a tadbikar or a middleman. There may be a cases where person may be old and disabled. Now circumstances has been given and cannot undertake a long journey to affirm the affidavit. In such cases, he may authorize one of his relative or friend and who may be briefed by him, but in each and every cases, the said principle cannot apply. And the applicant has to file the application for anticipatory bail by swearing an affidavit himself. In our view, if the system of tadbikar filing application under section 435 of the Code of Criminal Procedure is allowed to continue, that would be encouraging a system contrary to law, and that would encourage toadsome and middlemanship in the legal system, and this system is bound to cause destruction to the present judicial system. If middlemen have to stake accepting that they are doing this for wrongful gain, and the possibility for such making wrongful gain is there, and there is also admitted by the member of the bar before this court that lawyer when moving an anticipatory bail could not get any instruction for the applicant, nor could they see the face of the applicant. There may be cases where the applicant may stay in a foreign country or is remote place of the country, hiding himself, and mere sending a wakalatnama, and merely on the basis of wakalatnama sent by some means, the middleman and the talabakar who are nothing but taught could not be allowed to function, and it does not require the exercise of any skill and research that person are polluting the system. 26. We also hold that this court and no other court in this state can entertain an application for anticipatory bail if it is affirmed by a mere tabakar, and not such application can be entertained unless it is supported by an affidavit by an applicant or duly his authorized agent in accordance with law, and not by the tadbakar or a middleman. Similar view taken by the Madhya Pradesh High Court also in case of so and so, and the relevant observation of the High Court are reported below. The present situation is arisen because the petitioner under section 430 of the CRPC was filed without being supported by an affidavit. Mr. Rajendra Singh, SC Datta, so and so, learned counsel fairly stated that if the application for anticipatory bail is supported by an affidavit, then litigant would not be able to put the blame on the counsel and unpleasant situation would be avoided. It is incumbent on the person who seeks to obtain the privilege of anticipatory bail to satisfy the court that there is apprehension for his arrest. This is the condition precedent to invoke the jurisdiction of the court
These
under
are not
430
applicable in my case, my lord.
In view of the aforesaid, I am of the considered view that a heavy onus is cast on the applicant seeking the privilege enshrined under section 438 to satisfy the court that he is entitled under the law to obtain such concession. It is to be borne in mind that an application under section 438(1) of CRPC has to be applied by a person who has reason to believe that he may be arrested upon acquisition of having committed or bailable, non-bailable offence. The language used by the parliament, he may apply to the court, your lordship. Thus, an application by the accused is mandatory. Existence of the reason of belief has to be based on a bona fide reason or belief, and it is sine qua non. It is to be noted that the bona fide reason to believe is not a colorable belief. The accused has a special knowledge with regard to his apprehension. This court has an obligation to scrutinize the same with objectively of the approach to find out that there is a proof of his apprehension. Hence, the application has to be supported by an affidavit of the applicant or by the family member or a friend or paroker who has been duly authorized by the applicant. The authorization should be filed along with the affidavit. This would subserve the cause of justice and strike a balance between the individual liberty and concept of composite restraint. It is not to be noted here that an application under 430 of CRPC can be made to the Court of Session. It is hereby made clear that every application under 430 CRPC filed before any court of law should be supported by an affidavit as been indicated above. Lastly, it is submitted by Mr. Chakrabarti that the bail application may not be rejected for the conduct of the applicant, as he has to obtain the concession of anticipatory bail. Nothing the aforesaid submission of the learned counsel for the applicant while declining to the enter his prayer for bail under these circumstances. I am inclined to observe that the applicant would be at liberty to file a properly constituted petition which shall be considered on its merit. I also find out one wakalatnama on record which purported to have been signed by Gopal Goyal Kanda in favor of some advocates. This wakalatnama is shown to have been executed by Gopal Goyal Kanda on 13 August 2012. However, one of the advocates whose name appeared to be in Ravinder Singh has put his signature for identifying the executant of the wakalatnama, but the advocate put his signature on 8 August 2002. This creates a suspicion in the mind of the court regarding the genuineness of the wakalatnama also. In any event, if the anticipatory bail application has actually been moved by the Gopal Krishna Kanda himself, he had engaged advocate for that purpose by signing wakalatnama in their favor, then there was no occasion for his brother or Paraskar to have given instruction to any counsel for filing this anticipatory bail and application, and that too without any authorization in his favor from Gopal Goyal Kanda, and also without any reason for Gopal Goyal Kanda himself not giving any instruction to his own advocate for filing anticipatory bail application. In my view, this anticipatory bail application is liable to be rejected without going into the merit at all, only on the ground that the same has not been filed by the person apprehending his arrest. This police file show that even though the incident has taken place on so and so, the FIR was also registered in so and so, so and so. Here, your lordship, the circumstances has also been explained. There may be a circumstances, the accused, because of the old age, he may be unable to come before the court in such circumstances. So therefore, in the affidavit itself, the accused has to, or the deponent has to disclose why they could not come before this court or
Where have you said that you apprehend or they apprehend this arrest? Which paragraph?
My lord,
Which
My lord.
paragraph they have said that they apprehend their arrest in connection with the police case? Where have you said that paragraph?
my lord, my authorization,
No, just my query. In which
my lord, page,
paragraph?
6, my lord. Paragraph 6.
Yes.
That the,
Yes,
that the
yes.
petitioner beg to state that as some money was seized from the bank accounts of the present petitioner by the investigating officer. Now he issued notice dated 1/3/2024 to the petitioner under section 141A of the CRPC, asking them to appear before the investigating officer on 6/3/2024 at 1 p.m. Accordingly, though the petitioners are ready and willing to appear before the investigating officer to cooperate with the investigation, but they are apprehending that if they appear before the investigating officer, they may be arrested in connection with this case on suspicion. My lord, they were issued, my lord, notice, my lord.
Okay, so why they could not sign? What happened to them? What is the
My lord,
reason
they
that
signed, my lord, Wakalat, only my lord, apprehending arrest, my lord, authorization letter I have annexed, my lord, last page of the petition, my lord, authorization letter is there, my lord.
What is the reason that they could not sign the affidavit?
Because, my lord, they were apprehending arrest, my lord. If they comes, my lord, because they are from, my lord, Assam, Hailakandi, my lord, district. And they, my lord, thought, my lord, if they comes, my lord, they may be arrested. Therefore, my lord, authorization letter, my lord, last page of the petition, my lord, there is authorization letter given to their family friend, my lord, and thereafter it was filed, my lord, which is supported by the rule of the our Guwahati High Court, my lord. But, my lord, here in this case, my learned friend referred this judgment, my lord. There, my lord, apprehension of arrest, my lord, of the petitioner was in question, my lord. Here in this case, my lord, we are issued notice, my lord. Our notice is my lord, page, lordship, kindly have a look. Our notice is issued to all the four petitioners from page, my lord, 24 onwards, my lord. Page 24, one notice, my lord. Then, my lord, page 25, another notice, then page 26, then page 27. My lord. All the four petitioners were issued notice to appear before the IO, my lord, because some money was also, my lord, seized from their account, my lord. And main accused of this case is their, my lord, family members, my lord.
What do you mean by family members?
Family member, my lord, petitioners, my lord, before your lordship is, my lord, the younger brother and he is professional doctor of, my lord, main accused Habibur Rahman, my lord. And, my lord, two is also his another brother, my lord. And, my lord, his wife and his cousin brother, my lord. They are not main accused, my lord. And, my lord, as per interim order, they appeared before the IO. Then, my lord, twice appeared before the IO. And other occasions, IO was not available, my lord. Even then, my lord, IO filed one IA, my lord, objecting the bail prayer, my lord. So, my lord, the petitioners before your lordship are apprehending arrest. There is no doubt about, my lord. And in this regard, my lord, very recently they have filed joint affidavit by the informant and the accused, my lord, with the agreement how the matter is resolved between the parties, with the undertaking to give, my lord, 2 crore 20 lakhs to the informant, my lord. And to that extent, my lord, already 1 crore paid. And rest 1 crore 20 lakhs to be paid within next 6 months, my lord. So matter is, my lord, your lordship, my lord, granted bail to main accused, regular, of course, regular bail, where your lordship considered all aspect, my lord, and your lordship being satisfied that it is a monetary dispute between two friends, my lord, and my lord, landlord and tenant, otherwise they are. Your lordship granted regular bail to the main accused, my lord. And in this regard, my lord, I beg to refer bail application number 20 of 2024. Your lordship disposed of this matter on 8/4/2024, taking into account all the matters that, my lord, matter is amicably settled between the parties, as well as, my lord, it is a monetary dispute between two friends, my lord. And main crux of this FIR.
Just a minute.
My lord, my
See
lord.
the page 32 authorization letter. Same person has written.
Yes, your lord. Your lordship, they have not annexed the authorization in our petition, your lordship.
Same person. Same handwriting has written 3 names. Same handwriting.
In fact, your lordship, this kind of practice is not
This will problem.
not taken cognizance by this court, your lordship. It will become a bad precedent, your lordship.
Not filing even separate bail application for
Yes,
each
your
one.
lordship. Four
And
of
they
them
will
are
be
filing.
waiving the court fees also.
Yes, your lordship. 4 anticipatory bails are binding.
This practice may not be allowed.
My lord,
this
in
court.
our, my lord, principal bench, my lord, we always file, my lord, common, my lord, petition. Of course, my lord, they should be under the same PA police station case, my lord. If they are, my lord, common accused, my lord, common bail application by common, my lord, ground, my lord, always, my lord, it is entertained, my lord. And, my lord,
Do you have
this
the
ground itself, my lord.
Just a minute. Do you have the copy of the authorization letter?
Yes, my lord, I have already annexed, my lord, in the bail petition.
It is the original,
Just
perhaps.
see the authorization letter. If you have the copy,
Yes, my lord.
same handwriting, 3 name.
Yes, my lord. Because, my lord, they were, my lord, apprehending, my lord, if they come, my lord, in Arunachal, they may be arrested. Therefore, my lord, the four petitioners, my lord, authorized their family friend, my lord, and he came and filed, my lord.
Where they have stated that they are apprehending their arrest if they come to Arunachal. Where they have stated the reason.
Yes, my lord. Paragraph 6, my lord, they stated, my lord.
No, paragraph. In paragraph.
Paragraph
Your
6,
lordship,
my lord, they received, my lord, notice under section 141A, and they are willing to appear, but they were apprehending if they comes, my lord, they may be arrested.
Then if this petition is allowed, then none of the accused will sign the affidavit.
Yes, your lordship. Absolutely correct, your lordship.
And then you see this
My lord,
exact
my lord, in this case, my lord,
this handwriting or who signed this
my lord, I have
authorization
no
also
problem. I can
not
still, my lord, file affidavit, my lord. I have no problem, my lord. Still, I
No,
can
no.
file affidavit. But, my lord, about, my lord, High Court rule, my lord. If High Court rule, my lord, permits, my lord, any person having cognizance of the facts and circumstances of the case, my lord, he can swear affidavit. And when this matter was filed, my lord, this was, my lord, objection raised by the, my lord, local registry. And it was communicated with the, my lord, registry of the principal bench, my lord. And the testimony discussion was held. And thereafter, my lord, this matter was posted before this honorable court, my lord. In a, my lord, my lord.
it was filed before
It was filed, my lord, when initially filed, my lord. This same question was raised by the registry of this, my lord, bench, my lord, Itanagar bench. Then, my lord, I personally present there, my lord, first day, and I had shown this provision before the registry, and registry thereafter consulted with the, my lord, the registry of the principal bench, my lord. Then, having satisfied with consultation that we have practiced, we can pass this kind of bail petition. Thereafter only, my lord, this matter was reported and placed before your lordship. And, my lord, here, my lord, the judgment which was, my lord, referred by my learned friend, it is, my lord, it is on the facts and circumstances that, my lord, court was not satisfied that that petitioner of that case, my lord, is actually apprehending arrest or not, my lord. But here, my lord, perhaps, my lord, there may not be any doubt that these petitioners are apprehending arrest, my lord, and they were issued notice to appear before the IO. Only, my lord, they were apprehending that they may be arrested. And in that judgment, my lord, there was no support. Every day, my lord, we are moving such kind of petition before the principal bench, my lord. Never, my lord, such kind of objection was raised, my lord. My lord, I am not getting sound, my lord. I am not getting sound, my lord. My lord, I am not getting sound. Not getting sound, my lord.
this.
Yes,
Can you hear?
Yes, my lord.
This signature, one person has put a signature, wrote the name of three persons. This may also be, of course, to check
Handwriting expert. Your Lordship.
handwriting expert, through handwriting expert. Then you may have to face another criminal, you see, allegation against you, against the petitioner. I don't know the practice there, but then this I have seen for the first time, one person signing in the name of three person, and then the family friend, one person signing for four applicant in one application in 438.
And your Lordship, the six, he's indicated. Actually, your
lord,
Lordship, according the para 6, your Lordship, as per my understanding, it should be, your Lordship, it should be in the manner that the deponent beg to state that the petitioner, it should be by the, your Lordship, the affidavit who swear the person who sworn the affidavit, the statement, it should be from his end, your Lordship. The deponent beg to state that the petitioners, on behalf of the petitioner, he has to be stated. Now here, petitioner stating for themselves, your Lordship. Now, if tomorrow, if any, your Lordship, statement, false statement is found contrary to the statement made by the petitioner,
my lord,
then against
may I
whom this
submit
court will
one thing,
take
my lord,
cognizance, your
without,
Lordship?
my lord, may I submit, my lord?
Can you, just a minute, can you show the similar cases in the principal seat?
My lord,
One person signing for four applicant in 438, and then
My
one
lord.
person signing for three, one person give a signature of three person. Can you just satisfy the court?
my lord, at this stage, my lord, I may be permitted, my lord.
We'll give you an opportunity to show, because we need to know. Because
Yes, my lord.
because principal seat, whatever is adopting in the principal seat, if it is a good you see,
Yes,
practice, we'll have
practice
to
of that.
adopt that the same. And if we can't, you see, same court can't adopt two different procedure. So we
My
would
lord,
like
my
to
lord.
adopt, you have to satisfy.
My lord.
So
My
when?
lord, only thing is that, my lord, here, my lord, petitioners are, there are four petitioners, my lord.
And then see, so we may have to call the accused. They are not the petitioner.
Yes, your Lordship.
Yes, my lord.
Accused.
My lord, they
to
may be
appear
allowed to file
personally.
affidavit, my lord. Directly, my
your
lord.
Lordship.
They have to appear personally before the court.
Yes, your Lordship.
Yes, my lord, they will appear, my lord, and they may be allowed to file affidavit, my lord.
And then if they claim that this is their own signature, we may have to send it to expert.
My lord.
We can't allow.
My lord.
This court will not allow. This court at least will not allow.
My lord.
When do you want the matter to be fixed? You have to satisfy that this practice is being practiced in principal seat. You have to show.
My lord.
There can't be a different procedure being adopted in the same court. Huh?
My lord.
We'll have to have it there. So when do you want? On the
My
same
lord,
day, the accused person. Yes.
My lord, accused person will, my lord, appear and file affidavit.
No.
That will do later on. They are
My lord,
bound to
unnecessary,
if they
my
want-
lord,
if they want-
unnecessary, my lord, controversy, my lord, is not necessary in this matter,
no,
my
no,
lord. If your lordship is
this
not
we can't,
satisfied,
No,
my
we
lord,
can't.
if your lordship, my lord, if your lordship is not satisfied on this procedure, my lord, petitioners will come.
It's not a question of my satisfaction or not. The
My lord.
question of the procedure
Procedure, my lord.
followed in the court. Procedure followed in the court.
My lord, this is, my lord, this is very much clear from the, my
And
lord.
they are accused, and mind you, they are accused persons. They should behave, at least.
My lord.
One person signing in the name of
No, my lord. Affidavit signed by their family friend, my lord.
Who is this family?
My lord, lordship, kindly have a look, page, my lord, 13. Page 13, my lord. His name is there, my lord.
Page 30.
13, my lord.
30 is the order of the court.
My lord, page 1313 of the petition, my lord.
1-3.
1313,
Affidavit,
yes, my lord. It is, my lord, Zakir Hussain, my lord. Zakir Hussain, my lord, he is on the affidavit. And my lord, lordship kindly have a look, last page, my lord, this Zakir Hussain was authorized by the authorization letter by the 4 petitioners, my lord.
Even the authorization is in question, Your Lordship, the validity of that authorization. The signature seemed to be done by the same person, Your Lordship.
See, the
My learned
petitioner-
friend is, my lord,
Just a minute, just a minute, just a minute. The petitioner nowhere appears, never signed, never authorized, but in still you see the statement, the petitioners are the place in the district so and so. The petitioners were arrested. So then the practice will have, will change if we allow this.
no, my lord, my humble suggestion is that, my lord, simply, my lord, these petitioners will come, my lord, and they will file affidavit, my lord, additional affidavit, my lord. If, my lord, my learned friend is, my lord, suspecting that whether they have filed the petition or not, my lord, the lordship, they may be allowed to file their affidavit, my lord. Individual affidavit or joint affidavit, my lord.
Okay. Mr. M. Bodhuyan. Learned counsel for the petition of video conference. Also had Mr. Hete, learned additional people for the state.
Your Lordship, informant is also present, Your Lordship.
Okay,
Yes, yeah,
your informant.
yes, Your Lordship, on behalf of
Okay, you have
informant.
anything to submit?
Yeah, Your Lordship, I have already filed the appropriate affidavit on behalf of informant, Your Lordship.
That you have filed affidavit also?
Yes,
for
Your
what?
Lordship.
Saying what?
Saying we have compromised the matter, Your Lordship, outside the court, Your Lordship.
Okay. So that can't be.
Yes, that is different aspect, Your Lordship. That cannot be
In that case, you have utilized the machinery of the
Yes,
state.
exactly.
And then if there is any rules
Yes,
on law, then the fine can be
yes,
imposed.
yes. There is
Because
absolute
see-
abuse of process of the court, Your Lordship.
Abuse of the process.
Yes, Your Lordship.
Typical.
Now, the bail application is filed in this manner. They have in the meantime come with the settlement. Your Lordship may kindly see the record obtained by during the course of investigation, everything, Your Lordship.
Everything.
Yes, Your Lordship. Your Lordship, what humble prayer would be, Your Lordship, regarding this affidavit. Otherwise, this will set a wrong precedent, Your Lordship. Everyone
Yes.
come with the
No,
authorization.
Let us give them chance.
Yes, okay, Your
So
Lordship.
if not, if satisfied, okay, not satisfied, then they has to go.
Yes, Your Lordship.
This is a, my lord, monetary dispute between two friends, my lord. Your lordship already
Yes, yes,
considered.
that is different, that is different, not on that, not on that.
We
Yeah.
are not on that.
If money, not on that, we are not on that.
My lord.
On that, if you come for questioning, it automatically go also.
Yes.
And probably you have a case in there. But the manner in which the petitioner has filed this bail application, we are on that. Okay, so, the learning counsel for the petitioner.
With the, my lord, with all respect, my lord, with this interim bail, my lord, they appeared already before the IO, my lord, and they were released on bail, my lord.
That
Maybe,
will-
maybe.
Fine.
The
They
bail
will
is still
file, my lord,
pending.
individual
Yes,
affidavit, my lord.
record has been called for.
Yes.
So, but the record says they are cooperating, not,
Your Lordship, the IA we have filed, they were not cooperating, Your
they
Lordship.
are not cooperating also, see.
My lord, cooperating, my lord,
cooperating also.
only, my lord, IO make, my lord, illegal demand in this case, my lord, therefore, again and again harassing, my lord, otherwise, my lord,
File FIR against IO.
my lord, otherwise, my lord, twice
Indicting.
admittedly, my lord, twice they appeared before the IO, my lord, Even then he has filed, my lord, so interested, my lord, filed IA, my lord, to cancel the interim bail, my lord.
You want, should he record that because the IO is illegally demanding, that's why they are not appearing before the IO?
At this stage, my lord, not necessary, my lord. If necessary, we will file affidavit, my lord.
But you see, the IO, there is an allegation against the IO also.
Your Lordship, this is just a mere statement. Let them come with an affidavit, Your Lordship, in that case.
My
It's
lord,
a
my
very
lord.
serious allegation here. It can, Your Lordship has seen the way they are conducting, how they filed the affidavit and how they have obtained the interim protection and how they have settled the matter during the pendency of
Conduct,
this
my
case,
lord,
Your Lordship.
I have objection against
It's a- in
such
fact,
kind
Your
of, my lord,
Lordship, it's a
against such
travesty
kind of,
of
my lord,
justice, Your
submission, my
Lordship.
lord. Conduct is very good, my lord. Only they authorize, my lord, and file this petition, my lord. If, my lord, this is not, my lord, lordship is considering, they will file their affidavit, my lord.
See, Your Lordship, again,
Already, my
they are
lord,
taking
joint
so
affidavit is
casually. They are saying they will file affidavit. Why they have not filed
obviously,
it
my lord,
earlier,
they
Your
are
Lordship?
from the different state, my lord. They are not knowing about all the, my lord, road communications, my lord, and they are not main accused, my lord. Main accused, he was sometimes staying Arunachal Pradesh, my lord. They are his family members. They are completely unaware of the, my lord, every road communication, etc., my lord. Therefore, they apprehending arrest, my lord, family friend was sent, my lord. If any objection, my lord, definitely it is simple, my lord. It is not to exaggerate, my lord, in this matter, in this way, my lord. They will file, my lord, affidavit, my lord. Your lordship will consider, and if necessary, they will personally appear before your lordship because they are already granted interim bail, my lord. Now they have no apprehension, my lord.
The learned counsel for the petitioner prays for some time to file necessary affidavit. By the petitioners. Is prayed for, list this matter after 2 weeks.
Yes, deeply obliged, Your Lordship.
Okay, this, okay.
May I please, Your Lordship,
My lord, any date is fixed, my lord.
After 2 weeks. You
My
want a
lord.
date?
Kindly, any date may be because I am from Guwahati, my lord.
Okay, is prayed for by the learned counsel for the petitioner. List this matter on Mr. When?
As per its convenient, Your Lordship.
When do you want?
Well, after 2 weeks, any date, my lord.
After?
After 2 weeks, any date, my lord.
After 2 weeks.
After 2 weeks.
Your Lordship, then it will be after vacation only.
Then it will be after vacation.
My lord.
Okay. After vacation is what?
Yes, Lordship, Your Lordship, in that case, CD may be returned, Your Lordship. CD is with us.
Okay.
already. It may be returned.
Okay. So, after vacation would be
On 16th, Your Lordship.
16.
Yes, sir.
Okay, 16. Return the CD.
Yes, sir.
And that's 16, on which date the learned the learned NDPS will produce the updated
Yes, sir.
case diary.
Deeply obliged, Your Lordship.
may I please, Your Lordship, here I am not the counsel, although 19, Your Lordship. I am not the counsel in the present
18
case.
over. June, no? Okay, 19.
Obligement.
What is this matter?
Lordship, this is an MSc
appeal.
appeal. I am not the counsel in this case, Your Lordship.
Okay.
I have received a message, Your Lordship. So the conducting counsel who is suffering from severe fever and abdominal pain, because of that reason he could not come.
Okay.
So the matter may be fixed after the vacation.
You are
anyway.
appearing on behalf of the learned counsel for the appellant.
Yes, Lordship. Yes.
Okay, you are for
I'm for the R1, respondent number 1.
respondent. Okay.
Lordship, but in this case, we have a small prayer. That Lordship, since August of 2023, this matter is being adjourned at this stage repeatedly, Lordship.
It was
On one,
hard.
no, I'm not, if it is an health issue, Lordship, it would not be proper for me to object today.
Okay.
But Lordship, since August of 2023, this matter is pending for hearing, Lordship. Now-
What is disposed of?
There was IA was
IA is
disposed of.
interim
Yeah, the
protection
IA
order.
stay has been
disposed.
given. Yes, IA in an IA, an interim stay has been given to in regards to the execution proceeding.
Whether the insurance has deposited?
And
Petition deposited.
petition, not deposit.
The IA was.
Oh, this is not insurance.
No, this is from the
Okay.
owner.
Whether any direction for deposition of the,
Deposition
no,
was
that is
not.
not there.
not there.
No, no, Lordship, in this regard, we were trying to dispose it of early. That is why this prayer was not pressed by us.
A fixed date
But
may be
Lordship,
given
still
to Lordship
thing,
in that case.
Lordship,
Well-
if the matter is adjourned today, Lordship,
Just a minute, huh? This IA not disposed of, it appears.
Lordship, the
There
IA
has been a
the
stay.
IA interim order was passed, probably by saying that, till the
What is
objection.
the total amount? What is the total amount? Awarded amount?
Lordship, the awarded amount is 30 less.
Stay over there, where?
It's in the I, Lordship.
By which order the operation was stayed?
It will be in I 195, Lordship, the order.
I 195, this is I 195 only. Just a minute. Till execution is fine. The present application.
Yes.
Whether you have filed any objection?
Yes, Lordship. On 2023,
No,
Lordship.
because by an order dated 29/22,
Yes,
No
sir.
objection.
the order says that till the objection is filed.
Yes, Lordship. Lordship, in this regard, if I may,
Hmm.
Lordship, on 27/2023, a hearing was there.
27
20/07/2023.
in
Uh,
IA.
No, in the main appeal. Then during the main appeal, Lordship,
Hmm.
it was submitted, we had applied to the honorable court that there is a stay. Then this honorable court was of the opinion that on 8/8/2023, a direction was given to them that within 1 week to the insurance company, you file your reply and then we'll dispose it of. There was a direction by 8/8/2023.
The insurance company is there also there.
Yes, yes, respondent number
Respondent
2,
number
Lordship.
2. So the direction was to the private.
To file, they were seeking some time to file some
No,
documents.
award was against the private.
Award against the owner, Lordship. The
Against
appellant.
the owner of the vehicle.
Yes,
Not against the insurance.
No, Lordship.
So why the insurance has been made party?
Lordship, they made a party.
The entire facts I cannot.
Okay.
Lordship,
say
if I may.
There is a
briefly, Lordship.
difficulty.
No, the petitioner appellant is not there.
Yes.
So no point.
So, Lordship, if I
That
may,
case, hmm.
a small prayer that if today it is adjourned,
Hmm.
it may be kindly reflected that this may be the last time it may be adjourned, Lordship. Because it has been adjourned
Later,
since.
endeavor
one-
shall be made to dispose of the matter on the next day. That may be mentioned.
No further
And a fixed
adjournment
date-
may be given,
a
Lordship.
fixed
The
date may be
hearing
given.
is automatically, it will, is with the intention to dispose of only
Yes, Lordship. But there is a
in the hearing.
adjournment seeking, Lordship.
Just a minute.
That is an issue.
Probably, I think insurance has also not filed anything.
Mr. Singh, huh? Okay, Singh. Appearing on behalf of the appellant, some Mr. the conducting counsel. Who is the conducting counsel here? T. Bhagan. Mr. T. Bhagan is indisposed. And prays for adjournment. So, Mr. G. Talal, counsel for the respondent claimant who is present. Yes, prayed for by the counsel for the party. List this matter.
Lordship, can it be a fixed date on 16th of July after opening of the vacation?
After vacation.
We would have liked it next week.
16
Lordship, if
July.
possible.
Okay, so 16 July? Okay, we don't know. Okay. 16 on 16. As prayed for by the counsel for the party. List this matter on 16 July, huh?
Much obliged.